Assalamualaikum and a very good evening to my beloved lecturer, Dr. Muharis bin Muhammad and fellow friends. Today, my group will be present about Malaysian Consumer Protection Act 1999. Let us introduce ourselves first. My name is Ruwaidal Hanan Binti Abdullah and my metric number is 275569.
My name is Aiman Muzammil Zaidi and my matric number is 275382.
And my name is Najwa Binti Sapian. My matrix number is 275339.
Without further, I will explain about this act. Malaysian Consumer Protection Act 1999 come into force on the 50th of November 1999 to provide legislative provisions for consumer protection. First and foremost, the Malaysian Consumer Protection Act 1999 is an act to provide for the protections of consumer, the establishment of the National Consumer Advisory Council and the Tribunal for Consumer Claims, and for matters connected. Under the Consumer Protection Act 1999, consumer rights cannot be taken away from them. This is despite the conditions in any agreement they have signed, and consumers also have the right to all the products and services for their daily basic needs, such as food, clothing, health, education, and a home. Other than that, the Consumer Protection Act has undergone several amendments since its enactment to cover various emerging issues relating to consumer, including the inclusion unfair contract terms, inclusions of credit sales agreements of goods, and the most recent amendment on 23 July 2019 related to Tribunal for Consumer Claims Malaysia. Next, as mentioned, the Consumer Protection Act, through many rounds of amendment, is a very comprehensive piece of legislation, covering almost every aspect of consumer protection, ranging from misleading and deceptive conducts, false representations and unfair practices, safety of goods and services, unfair contract terms, guarantee in respect of the supply of goods and service, and product liability to the establishment, structure, and functions of the National Advisory Council, the Committee on Advertisement, the Tribunal for Consumer Claims, and other matters related to enforcement, offences, remedies, and compensations. Last but not least, the government agency which is primarily responsible for policy making and law enforcement on consumer protection in Malaysia is the Ministry of Domestic Trade and Consumer Affairs, MDTCA. The MDTCA is also responsible for receiving consumer complaints and act as a secretariat to the National Consumer Advisory Council, NCAC. NCAC is an institution established by the Minister of Domestic Trade and Consumer Affairs to advise him on any relevant consumer issues and the implementations of the CPA.
Next, I will explain about the important point in Malaysian Consumer Protection Act 1999. This law provides simple and inexpensive compensation for consumer complaint and specific relief. It also provides greater protection for consumers, and its provision cover areas that are not covered by other prevailing laws. The Consumer Protection Law governing the supply of goods and also services have been able to provide a protection scheme that can further strengthen consumer rights and also interests. Next important point is the Malaysian Consumer Protection Act 1999 is rights of consumer, which highlighted about the right to be protected against marketing of goods and services which are hazardous to life and also property. The right to be informed of the quality, quantity, potency, purity, standard, and price of goods or services, the right to be assured of access to a variety of goods or services at competitive prices, and seek redressal against unfair or destructive trade practice. Next is the advantages of Malaysia Consumer Protection Act 1999. First is it protects the right of consumer, and second, it protects consumer on even more unfair terms, and the third one is it does not only apply to consumer contract but also to commercial contracts. The it, it protects the right of consumer. The advantage of the acts is that it protects the right of consumer. This fit with the act's objective, which is to provide greater protection for consumer, and its provision cover areas that are not covered by other prevailing laws. The Act provides simple and inexpensive redress for consumer grievance and specific relief. Consumer rights have long been ignored and manipulated by merchant and service provider to force consumer to accept all conditions in order to enjoy product or services. But this is changing since the Consumer Protection Act was enacted in 1999. The next advantage is it protects consumer on even more unfair terms. Other than that, the advantage of this act is that it not only protects consumer rights, but it also protects consumer on even more unfair terms. An unfair term in a consumer contract is one that, in the context of all the circumstances, creates a major imbalance in the party rights and duties resulting from the contract to the disadvantage of the consumer. This disadvantages the consumer due to a significant imbalance between the parties. But with the implementation of this act, the table is turned and the consumer gains an advantage on unfair terms. The third advantage, it does not only apply to consumer contract but also to contract. On the other hand, the advantage of the act is that now it does not only apply to consumer contract but also to commercial contract. Previously, the Consumer Protection Act of 1999 was criticized because it only applied to consumer contract and not to business contract. For example, product or services purchased by an individual consumer for personal use. This has changed because, according to the new Section 24B of the Act, the requirements of the Part 3A will apply to all contracts. Instead of simply adding a new section to an existing piece of consumer protection law, they have integrated the concept of Part 3A of the Act to extend the principle beyond consumer contract. It is proposed that by putting the new part within the Consumer Protection Act 1999, the new part only applies to consumer contracts that are protected by the Consumer Protection Act 1999. Next, I will pass to the next presenter.
I will continue with recommendation on this Malaysian Consumer Protection Act 1999. First is government objective, specific provision, reform of the law, safety and protection. For the first one is reform of the law. While it is recognized that the policies, laws and approaches by industry players are the main instrument to protect the interests of travel package or hospitality industry, the inadequacy of its substance and implementation must be addressed. However, for guaranteeing its effectiveness, the policy and the law must be reformed. Second recommendation for this act are specific provision. A specific provision relating to the compliance and enforcement of information provision should be allocated. In this case, where the licensed tour operator or travel agent fail to provide information relating to travel package as required by the law, they will liable and civil penalty, which is fine and imprisonment, will be imposed. It is the duty of regulator to enforce the said penalty as to ensure that it is can effectively take place. Third recommendation for Malaysian Protection Act 1999 are Malaysian government objective. The Malaysian government should set objective toward producing capable consumer and effective consumer protection. However, it does not change into practice when the policies were left without any further action. The government has recognized the need to specific enactments for provide better consumer protections. As a result, the Malaysia government enacted Consumer Protection Act 1999 to protect the rights and interests of consumer after protracted year of struggling by the consumer movement. Nevertheless, the protection prescribed in the CPA 1999 does not correspond well to the current demand 256 of protections by the consumer, including Umrah and Hajj package and travel package. Last but not least, about the recommendation on this act are safety and protections. By looking to the current demand for safety protection and current agitations, information of safety threat is essential to be provided by the local tour operators and travel agent to the package traveler. Failure to provide information of any threat might affect the safety of travelers. For that reason, it should be a compulsory for licensed tour operators and travel agents to provide information in relation to the safety of travel trip destination at the pre-contractual stage as they allow the package traveler know the real conditions of place as well as to make the best decision before they enter contract. The tour operator and travel agent should provide the information in relation to the safety threat by referring to the current advice from the government agencies. In conclusion, it is a critical to take an integrated, holistic, or system approach to consumer protection. The work of developing smart consumer who can protect themselves, as well as ethical business and educating consumer protection laws, should continue. All parties, including the government, traders, consumer, and non-governmental organizations, should work together to ensure that Malaysian consumers are well protected. All these initiatives will help to combat consumer ignorance, disorganized consumer, illegal product, deceptive advertising, business malpractice, monopoly power abuse, pollution, and a variety of other issues that affect consumer well-being. In the context of civil liability, imposed on supplier or trader, legislation such as Consumer Protection Act 1999 are more the law that give consumer right claims directly against supplier or traders of goods and services through there is still room for improvement. That's all from us. Thank you for watching. Have a nice day.